Good evening. This is John Milburn for Laws 12062 Alternative Dispute Resolution. This is week 2 in Term 2, 2017. Tonight we're going to do something which is a little different, certainly for me, and that is use PowerPoints. Those of you that have worked with me in the past know that I really have an aversion to PowerPoints. They seem to constrain things, in my view, and make life less informative rather than more informative. Having said that, I'm going to share the screen now and start this presentation. The presentation is one where I do encourage you to ask questions as we progress and don't feel constrained in that regard. Now, hopefully you can see some PowerPoints up on the screen. If you just give me a nod if you can see that. Some PowerPoints? Yep. All right, good. And I know I'm not presenting this in the proper way. I've got the side parts organised as well. All right, so tonight's presentation is the presentation that I gave last year as part of a CPD intensive for solicitors through the Queensland Law Society, and it's about applied skills in mediation and conciliation. And you'll see that there's the Queensland Law Society logo there, so I hope that the Law Society sees this as an advertisement for their services, and you'll see that I carefully retained copyright in the material, anticipating that I would use it as I'm doing now as part of the ADR sessions for CQU. So in applied skills in mediation and conciliation, my intention is to provide some insight as to what a mediator or a conciliator does and give you a better opportunity to apply those skills when you are acting as a mediator or conciliator, or alternatively, to give you an idea of what you can expect from a mediator or conciliator and how you can prepare a client for the mediation or conciliation process. As you know, I'm pitching this course for those people that wish to practice. So you'll often see me or hear me talk about what you might do in practice, your hypothetical clients, and many of the exam questions that I set are pitched to a level as if you are a first-year lawyer doing something in practice. So that's pretty common for me. So tonight, assume that you are in practice, either as a solicitor or barrister, advising clients that are going into the mediation or conciliation process, or you are the solicitor or barrister who is conducting the mediation or the conciliation. So they're the skills that we're talking about and how to apply those skills. So the premise is practical in nature. And from what we talk about tonight, you may prepare checklists. We may deal with the process of planning and preparing and then implementing various strategies and techniques that are useful in the ADR context. And some of these techniques are actually used by ADR practitioners, and these are the things that I use in practice. Now, when you're preparing a client for ADR, or you are the ADR practitioner, bear in mind that your paramount duty is to the administration of justice. For example, Rule 3 of the Australian Solicitors Conduct Rules provide for that. And as an exam hint, you may want to be aware of the problems, ethical problems that are faced by mediators, conciliators in particular, in relation to conducting their work and the ethical issues that may arise. So remember, go back to that paramount duty about the administration of justice. If you're talking about ethical issues, that's always a good opening line. So the applied skills that we're talking about relate to, firstly, understanding the alternative dispute resolution options. There are, as we identified last week, and you would have read through your material, many ADR options that are available. The next skill that you need to have is an ability to explain those ADR options and provide suitable advice to your client. In order to explain the options and provide the advice to the client, it's critical that you understand the role of the participants in the ADR process. And that means understanding the basic ADR procedure, preparing appropriately for the ADR process, and then we'll talk about the skills that you need to participate in the ADR process and finalise it with some specific skills and deal with some specialty mediation and conciliation processes. Again, my apologies for using PowerPoints, but I hope you're bearing with me. And again, feel free to ask questions. Just unmute your microphone or use the chat facility. All right, last week we talked about the difference, in brief, between mediation and conciliation. And I know that mediation and conciliation are only two of a range of ADR options that are available, but they are very important options, and they're, if you like, the key ADR options in practice, the ones that are most commonly implemented or used. So mediation is a process, as is conciliation. Both provide for assistance to parties in a dispute situation, and in a mediation or conciliation, there is the common element of trying to discuss options and work towards an agreement. The difference really relates to the fact that in a pure sense, mediators don't advise or determine, and in a more practical sense, conciliators may advise. They don't have to, but they may advise, or if empowered to do so, for example, in my role as a QCAT member, make directions or orders. But again, there's a common element with mediation in that it's not a determinative process. So step number one in that list of things that we talked about in terms of applied skills is understanding the alternative dispute resolution options. What are those options? Well, there are many. If we look at David Spencer's text, he identifies 14 ADR options. This is not a definitive list. This is not the only list of options. Other authors may say that there are 6 options. Others may say there are 20. My personal view is that it's almost dangerous to categorise them and pigeonhole them. You can mix and match. There are hybrids of these options that are available. And we'll talk, time permitting, we'll talk about some of the hybrids that are available. So don't list in an exam question the 14 alternative dispute resolution options as a definitive list where there's nowhere else to look and no other options for creativity. There are, in fact, many other options that are available, and it's a graduating scale. And you can use a number of these different options in the context of providing advice to a client. As an exam hint, when it comes to the take-home exam, you need to think laterally, and it may well be that the advice that you provide to your client incorporates a medley of ADR options in some way or another. It may be that you work sequentially to provide options for ADR, or they work in tangent, or it may be subject to a flowchart where if something happens, then this is the appropriate ADR option. If not, a different option might apply. I know that's all very vague, and you're probably wondering what I mean by that last series of comments. But the point that I'm trying to make is this: be creative and make sure that you think laterally in terms of the ADR options. And you'll see that list of 14 ADR options by Spencer in his textbook. And you'll recall that number 1 is the least intrusive, if you like, ADR option. Number 14 is the most intrusive, for use of a better term, ADR option. Number 14, arbitration, is the most court-like of the options. It's a determinative process, whereas negotiation is the one that is the least intrusive in terms of ADR practitioners, process, or third parties generally. So before you can provide appropriate advice to a client in relation to ADR options, you at least have to know what those basic options are. Essentially, there are 3 main types of ADR process. facilitative, advisory, and determinative. Facilitative is where the ADR practitioner assists the parties to identify the issues, generate options, consider alternatives, and then hopefully reach an agreement. The key examples are mediation and facilitation. Advisory is where we take the facilitative model and add to it the feature of allowing for an appraisal of the facts or the law by the ADR practitioner and provide the ADR practitioner with the ability to provide additional comment, perhaps about a likely outcome. There are strict rules in relation to how a conciliator might do that. But examples are conciliation, case appraisal, or expert appraisal. The third broad type of ADR process is determinative, and that's where the ADR practitioner evaluates the dispute and makes a decision. The ADR practitioner may conduct a hearing and indeed receive or call evidence. And the examples of those determinative processes are expert determination, mini-trial, and arbitration. As you go through your reading in this course, you'll come to better understand what those processes are. But at this stage, it's important for you to understand that there are the three broad categories. But again, I go back to the comment that I made earlier. Don't feel constrained to fit within one of the main types of processes. You can be creative, and part of the dispute might be resolved through a facilitative process, and part of the dispute might be resolved through a determinative process. Think about those options when you come to a real-life scenario. Step number 2 is your ability, your skill in explaining those options to clients and providing appropriate advice. Now, the threshold question is litigation the most suitable method of dispute resolution, or can the matter be resolved through alternative dispute resolution? In some ways, that question is inappropriate, even though I've posed it as the critical threshold question. And the reason I say that it may be inappropriate in some circumstances, indeed many circumstances, is that while the ADR processes themselves can be used in a mix and match fashion, so too can litigation in its pure sense and ADR be used in a mix and match situation. In fact, as you'll learn in civil procedure or by reference to the UCPR or other practice directions or rules, ADR processes are now built into litigation process. So the point that I'm trying to make is that even though it may be that the answer to the critical threshold question is that litigation is the most suitable form of dispute resolution, be prepared for the fact, the likelihood indeed, that ADR will form part of that litigation process in any event. In explaining the options and providing the advice to the client, it's important for you as the legal practitioner to lead by example. Your demeanour, your attitude will influence the attitude and the behaviour of your client. Many older practitioners, and I mean that in terms of seniority, which probably means age, but more experienced practitioners are quite often split in this process. Some, like me, embrace and practice and advance enthusiastically the ADR options. Others do not. Others suggest that litigation, in its pure sense, is still the best way to go. I'm not here to advance one cause or another, because if we go back to the critical threshold question, I made it clear that it's up to you as the legal advisor to determine whether litigation in its purest sense or ADR is the most appropriate method of resolution. Just because I'm teaching ADR doesn't mean that I'm necessarily saying it's the be-all and end-all. Far from it. If I'm teaching civil procedure or evidence in proof, I'm talking about litigation and little about ADR, but now I'm talking about ADR. So even though my personal view is that ADR is very important and it should be considered as a realistic option, be aware that if you are dismissive of the ADR option, then your client is likely to go with you. Conversely, if you enthusiastically embrace the ADR option, so too may your client. So to protect your interests, make sure that either way, you obtain your written instructions to the client. As an exam hint, it's very likely that the question that will be asked of you in the take-home exam is putting you in the position of being a lawyer giving advice to a client. You will lose marks if you fail to accept or fail to acknowledge that obtaining written instructions from your client is a key part of the process. You've got to think about your own liability and the liability of your employer if you are employed. And it's important that you obtain written instructions from the client. So if the instruction from the client is to pursue an ADR option, make sure you get that in writing. Likewise, if it's litigation or whatever it might be. And that's not just an ADR piece of advice, that's general advice across the board. When you consider the options and provide advice to your client, it's important that you understand the statutory provisions that are relevant to ADR. At a Commonwealth level, the Civil Disputes Resolution Act provides that the object of the Act is to ensure that as far as possible, people take genuine steps to resolve disputes before certain civil proceedings are instituted, and that's Section 3. So you must look at that. So if you're giving advice to a client to proceed by way of litigation, be aware of the issue of taking genuine steps to resolve disputes before civil proceedings are instituted. So at a Commonwealth level, for example, one of the roles that I have is to act as a mediator in commercial disputes, franchise disputes, appointed by the Office of the Franchise Mediation Advisor, which is part of the ACCC. And it's built into the franchising code of conduct that before franchisees or franchisors initiate litigation proceedings in the federal court or otherwise, they must go through a process of attempting through genuine steps to resolve the dispute. And a key part of that is a referral through the Office of the Franchise Mediation Advisor for a mediation session with me or someone like me appointed under that franchising code of conduct. At a state level, there is the UCPR, and remember Section 5. This is really important, and again, I mentioned at the start that you should always talk about the paramount considerations. Also, you've got to talk about the objects and the philosophies in an appropriate answer to a question, even an advice to a client. You've got to remind the client of these important threshold issues. So in a state jurisdiction, UCPR, Section 5, the purpose of the rules is to facilitate the just and expeditious resolution of the real issues in civil proceedings at a minimum of expense. If the matter is protracted litigation, very costly, then when it comes to the way in which you advise the client, there may be issues as to how you can demonstrate that you attempted to expeditiously and justly resolve the dispute at a minimum expense if you failed to consider the ADR option. Also under UCPR, Chapter 9, Part 4, we have alternative dispute resolution processes, which are sections 313 or rules 313 through to 351. So have a look at those rules. I've said they're sections, but they're rules in the UCPR. If you don't have a copy of UCPR, you can obtain it readily online, and it's something now as you get further into your course that you should become very familiar with and very comfortable with talking about and referring to the UCPR. The same thing goes with practice directions. make sure that you're aware of the existence of practice directions in almost every jurisdiction that you're likely to practice. Okay, you're now at the stage where you're having preliminary discussions with your client about ADR. You have legal and ethical obligations to be very candid in your statements with your clients about costs and litigation risks. You need to be able to explain the best resolution process for your client. And sometimes that means doing a mock presentation of the case. Sometimes it means identifying the pros and cons in relation to the case. You need to genuinely reality test, and you need to determine what evidence you need to obtain and when and how to do so. And Jamie says, can we have a copy of these slides? And yes, I will provide them. That might help you writing everything down. But I'd still like you to write some notes. I don't know about you, but I always find if I write notes as I go, it actually sinks in better. If I'm just listening, I tend to nod off and wander, whereas if I'm writing, I'm having to construct something and I get to reinforce the information by seeing it as well as hearing it. So, yep. Okay, so that's the genuine reality testing. Now, I'll just go back to where I was. So you need to consider in that preliminary discussion what evidence needs to be obtained and when and how to do so. And when I talk about genuine reality testing, what I'm really talking about is to some degree challenging your client, doing a little bit of devil's advocate, as we say. That's what I mean by reality testing. Are they genuinely committed to the cause sufficient to warrant spending $100,000 and a year of their time in litigation, even though they say there is no way we can come to an agreement in mediation? I don't want to talk to him or her or them. It's a waste of time. Once you go through the reality testing process of what litigation really means, what it costs and how long it will take, they may come round to the idea of mediation. And can I just say this, in terms of mediation practice, almost every mediation I've got, I've been involved in, I'm sure other mediators as well, commences with the parties having a mindset that there's no way we can settle this. Because if there was a way they could settle it, they wouldn't probably be going to mediation. They probably would have already settled it. But given that the success rate in mediation is way up there, I don't know, 80, 90% success rate, it means that the process works because there are certain ways that we go about dealing with the issues to not force but encourage a settlement. So when we're giving advice to the client about the options, it would be appropriate, I think, for you to have preliminary discussions with your opponent and the ADR practitioner. So again, I'm tailoring these notes primarily to those people in practice who are advising clients in relation to ADR rather than the ADR practitioner. Now, if you speak with the ADR practitioner can design the session to suit your client's circumstances. That might be a telephone session, an audio-visual session. I use Zoom sessions for mediations, or a shuttle session. Now, a shuttle session is where we're all together in the same locality, but the parties are kept separate in separate rooms. And the mediator goes between the parties and rather than the parties being together. I think I mentioned last week, I'm not a fan of shuttle mediations. I know in past offerings of this course, people have assumed that the only way to conduct a mediation is through shuttle because that's their experience. But it's certainly not, and it's not the preferred option for me or I think a number of ADR practitioners. But the point is, that in the preliminary discussions with your client, you should talk about raising issues with your opponent, the ADR practitioner, and tailoring something to suit. And it's likely that the ADR practitioner will require the parties to sign an ADR agreement. That brings us then to the third aspect of the advice that you need to provide. You need to understand the role of the participants in the ADR process. What do the participants do? What are they expected to do in that process? The lawyer representing a party in an ADR session needs to consider the type of ADR. We've already talked about that. And this is a really important part, conceptually and in practice. As a lawyer representing a client, you need to allow your client to retain ownership of the dispute. It's actually a big selling point for ADR. You see, in litigation, the dispute is largely taken away from the client. It's placed almost certainly in the hands of the adversaries, the advocates, and the judge. The clients play a secondary role in a way to fill in gaps. But in ADR sessions, depending on the type of session you choose, the client has a real opportunity to retain ownership of the dispute. That's an important thing for clients, in my view. So what's the role of the client in an ADR session? Number one, retain ownership of the dispute. And number two, be an active participant. Don't be passive. And I think it's important that you try to advise your clients about their role as being active. We know that ADR practitioners are there to assist the parties to come to an agreement. And initially, the mediator will try to obtain some point of agreement between the disputing parties. In this instance, the mediator has sought common ground. First, can we agree that it's a big backyard? Get both parties nodding. Yes, it's a big backyard. All right, we're getting somewhere. And it's very common for an ADR practitioner to work on a series of questions near the start of the joint session between the parties to have them nodding in agreement. They're agreeing on a number of things. Can we agree that there's this? Yes. Can we agree this? Yes. Can we agree this? Yes. It gets them in a mindset. As a legal representative in the ADR session, you can use some of those techniques as well, and it's often advantageous for you to do so. Now, what is the role of the mediator? The mediator works on the agenda, keeps the parties focused on the issues and the problem. Be energetic and be alert. Now, Judge Kingham, who is now the president of the Land Court, addressed myself and others at QCAT in this manner and said, as a mediator, remain light on your feet. What that means is be ready to move and listen very carefully to a word or a phrase that might give you an in. You're listening carefully to the parties that clearly don't like each other and are expressing views that they just simply can't agree until somebody says a word or a phrase that gives you a chance to maneuver the conversation in a certain way which might assist the parties in coming to a dispute. You can only do that if you're actively listening and you remain light on your feet. I don't like PowerPoints because I'm stuck with a process. I don't mind doing it tonight. It'll probably be the only time we do it. But normally you need to be in a position where you can react. And that's part of the fun of being a lawyer, being able to be light on your feet and move from one thing to another. So what else does the mediator do? The mediator will open up an avenue for discussion. If that doesn't work, the mediator will regroup, try a different avenue. You're looking for an opening. You're up against, I don't know, whatever analogy you like. A brick wall, you're looking for a crack. You're looking for a weakness. You're trying to cross the Great Dividing Range. You're looking for Cunningham's Gap to get you to the Western Plains. You just keep, if you come up against a wall, regroup, move back, try a different approach. That's part of the skill of being a good mediator. And as I mentioned in the slide there, you're listening carefully for a word. A single word might give you that opportunity to move forward. Now, it's likely that a conflict has multiple causes. In a way, that's good because it creates multiple opportunities to resolve the dispute. And once you get one part of a dispute resolved, there is a dynamic where you can use a domino effect to knock over the other issues of concern. Now, how does the mediator do that? In practice, a mediator will go to the toolbox and use techniques involving rephrasing, summarizing, reality testing, etc. And you can read about those in your text. And we'll do some play acting to show what that means. So the mediator has a little agenda, a little game plan, which relates to what they wish to do and what tools they used to use at certain times. And you can't script this, and it's best not scripted. That's why in assessment number 1, I don't want you to have scripts. You can if you want, but I don't want you to. I want you to have basic guidelines for the dispute and let the parties take it in a certain direction and then use your skills as a mediator or conciliator to rephrase, summarize, reality test, etc. And in terms of the role of the mediator in an ADR process, to paraphrase Professor Adrian Ashman, also of QCAT, throughout the mediation, the parties might think of you as his or her new best friend. It's remarkable how often both parties will come to trust and almost like the mediator in the process. Think of it from their perspective. The parties have been at war with another party or parties that they clearly don't like. They don't get on with them. It's been stressful, expensive, draining. Now they've got someone in the form of a mediator or conciliator who is genuinely there to listen and to help, and you're going to like them. Here's a person who might help take away this pain that I've got. So there's nothing wrong with you aiming through the mediation process to be the new best friend of both parties. You're still impartial. How do you achieve that as a mediator? Well, it means you need to be light on your feet. You need to be personable. You need to maintain eye contact. You need to use all these different techniques. And you can't do that if you make it difficult for those people involved in the process to treat you as their new best friend. So what does a conciliator do? Well, essentially the same techniques as a mediator, but in addition, provide an assessment to the parties, preferably in private session, some sort of reality testing about the quality of their case perhaps, and require the parties to identify the material facts and legal issues so as to shorten and simplify the hearing of the matter. You see, sometimes you can't get a full resolution of the matter, but you can assist the parties considerably and shorten the length of any hearing by identifying and agreeing upon material facts and legal issues. So it may be that at the end of a mediation session, there are 6 points of agreement in relation to the facts and 3 identified legal issues that need to be answered. That's going to make the trial a whole lot quicker than starting from scratch. And if the conciliator has power to do so, the conciliator may make directions that identify the future conduct of the matter by a directions order, or possibly introduce an experts conclave, or include an agreement as to the material facts and relevant legal issues for determination by the court or tribunal at the hearing.
I'm sorry, John, could you just explain what an experts conclave is? I haven't seen the term before.
Oh, yeah, sorry, Karen. That's a really good question. And it's so easy for me to gloss over these things as if we've dealt with them before. An experts conclave is, in a way, a little bit like a mediation, but for the experts. So the experts get together, and their job is to come up with a list of things upon which they agree and a list of things upon which they disagree, and record that in a document, so that when we get to the trial situation, the court clearly understands what the issues are. They understand what we don't need to, that what the court doesn't have to answer. They can see the list of things that the experts agree upon, and then they can say, all right, so the experts disagree on this and that and this other thing, so we can now concentrate and deal with the evidence about those three things of disagreement. So it's a way of getting the experts together before the trial and coming up with essentially the real issues of concern in a summary way. Does that answer your question, Karen?
Yeah, thank you. So similar to case conferencing in a criminal setting.
Yeah, there's some similarity to that, yes. But it's a little bit more formalised, a slightly different way. And quite often, as I said, the experts conclave is often conducted with a mediator in charge, or a conciliator in charge of that process as well.
Okay.
Okay, thanks, Karen. So you must be working in the criminal law field, Karen?
Yeah.
Right. Okay. So. No, that's good. Well, there may be a question about case conferencing in the criminal law sphere as part of our exam.
Okay.
Okay, so Jamie says, a bit like a voir dire. Well, yes, but it's not with the court. So the case conferencing process occurs well before any court matter, but it does have some elements of a voir dire in that certain discrete parts of the case are decided at that stage. Pagan says, after looking at what a mediator or conciliator does, I feel like Dale Carnegie's book, How to Win Friends and Influence People. That's a really good point. And it is a matter of trying to win friends and influence people. Thank you for that contribution. That's actually spot on. All right. The fourth aspect is understanding the basic process. So we know that ADR is a process. What are the basic, well-accepted steps? There's an opening statement by the mediator. This week, you should probably start working on your opening statement for assessment number 1. There's an opening statement from participants. Following that, the mediator will work with the parties to set an agenda. Then there's a first joint session between the parties and the mediator, everyone preferably in the same room. It's very likely, but not prescribed, that there will be private sessions where the mediator meets with only one party and not the other. Typically, we go back into a second joint session, and from that, hopefully there's an agreement, or possibly, in the case of conciliation, further orders. That's the basic ADR process. In a shuttle situation, we don't have a first joint session. We go straight into private sessions. In other mediations, we don't have private sessions at all. In some mediations, we may have not 2 joint sessions, but we might have 4 joint sessions truncated by 3 private sessions. Every case is a little different. But that's the basic procedure. That's the basic process. The first thing that I like to consider is, in the joint session, asking questions that help to clarify or discuss factual matters. What do I mean by that? It's very common in a dispute that people have looked at the same thing from different perspectives and they see things differently. Consider the blind men and the elephant parable by John Godfrey Sachs as demonstrating the way in which different observers may relate to a common object. Here, individual blind observers describe an elephant as like a rope, like a wall, like a tree, like a fan, like a spear, or like a snake. Everyone is looking at the object from their own perspective, and it's very hard to work on an agreement if people are looking at things completely differently. So it's very common in an ADR session for the mediator to ask questions with a view to clarifying the facts about a matter, or at least opening up discussion about those facts. And what we're trying to do is have the parties consider the factual situation from a common perspective, or at least from the other's perspective, and open that up as well. Sometimes in that joint session, you need to overcome some difficulties. And one of the very common difficulties is dealing with a hardball negotiator, a take it or leave it type. Unless we settle this right now, I'm walking out. We see it all the time in mediations. Uri, a very well-known author in this area, says, okay, if you're confronted with a hardball negotiator, here's maybe what you should do. Number one, recognize the tactic. Number two, stay calm, recognize your own triggers, and just stop yourself. Put on your radar, says Uri, not your armor. And then name the issue. Use your reframing skills and seek an agreement on how to move forward. Another common problem that we have relates to veiled threats. We see this all the time. So how do you deal with a statement that is, at best, a prediction and most likely a veiled threat presented as a factual statement? Here's an example. If you stop selling my ice cream brand in your fish and chip shop, you are going to go broke within 6 months, guaranteed. It's stated as if it's a prediction, but really it's a veiled threat. And it's presented as if it's a factual scenario. It's stated as fact. So as a mediator, how do you deal with that? Well, some appropriate responses might be, in a very calm and open manner, okay, do you have any evidence to support that statement? What you're doing is you're calling the statement, you're acknowledging it, and you're asking for support for this bland statement. Others, well, can you give me some examples of where this has happened before? You're asking the person who made the statement, the veiled threat, to justify the position. Sometimes they don't like it. Sometimes one of the big problems that you have as a mediator is dealing with that type of personality and personal attacks. And it's very real. You need to be careful from a risk perspective as well. So what do we do if in a mediation session we have someone who is very aggressive, hostile, and looking to attack the person? Well, sometimes this is what you need to do as a mediator. You may need to divert and absorb the pressure yourself. If you allow that aggressive, hostile participant to go directly to the other party, you may lose the other party. It may be all over. So you may have to take some of the pressure yourself. Divert the hostility towards you. You know you can handle it because you're going to stay calm. You're not going to react or abruptly terminate the discussions. Sometimes good mediators don't raise their voice when others around them are raising their voice. They lower their voice or maybe slow the discussion down. You can only really do that if you've been able to maintain and establish control over the process from the start. But if you've done that, people will generally respond. Now, once you've got the hostile party's attention, use your reframing skills, and you'll read about reframing skills, and I won't go into it now, but use your reframing skills to deal with that situation. Avoid direct criticism. Don't take them straight on. It'll only fire them up. And maybe sometimes use a bit of good old reverse psychology. Recognize their strengths and their achievements, and then when you can, when you've settled them down a bit, carefully explain the consequences. Okay, we don't want to be too hostile. If we do that, we're not going to have any hope of a settlement, and we're then looking at litigation. Question from Jamie, is it common for students to sit in on a real mediation session, or is it a confidentiality issue? It would be wonderful if you could make contact with a mediator and try to sit in on some sessions. There is always the confidentiality issue, and that's the problem. But it would be great if you could do it. Having said that, there's some really good things online. There's some possible, I think some fake mediation sessions that you might be able to find online. If you do, please share the link on uCrew. All right, so number 5, preparing for an ADR process. The best preparation for tomorrow is doing your best today. In other words, unless you've prepared properly, things won't work well. So what can you do to prepare for the ADR process as the lawyer? Think about the likely conduct of the ADR, and bear in mind there's little realistic prospect of success if you fail to prepare well. Many disputes arise simply because of mistaken, poor, or accidental communication. So when you're preparing for ADR, you've got to be active. One mistake that I think some lawyers make, hopefully not many, but some lawyers make, is they think, oh, we've been ordered to ADR, we'll turn up and we'll see how things go. Almost doomed for success if you do that. Your role in acting as a lawyer for a party leading up to an ADR process is to work very hard. Part of that process is to anticipate opportunities that may present themselves and anticipate impediments, and then develop game plans in relation to both the opportunities and the impediments that you anticipate. So how do you prepare well? Well, the first thing to do is ensure that your client understands the process. We don't want a mediation session truncated because someone doesn't understand what the process is, or asking questions about matters that should have been clarified and explained before you got there. Make sure that your client is able to attend in person. Even though I mentioned that we do conduct mediations by telephone or audio-visual, the fact is that if the parties aren't there in person, you're not as likely to settle the matter. If you can't get there in person, at least make it an audio-visual session. It's much better than telephone. And make sure that your client does have the authority to settle the dispute. What we don't want is 3 hours into the mediation for your client to say, well, I am a director of the company, but I don't have authority of the company to come to a final settlement. That sort of thing should be sorted out before you go into the mediation session. Make sure before you go into mediation that your evidence is sufficient. Have you obtained your witness statements? Do you need to obtain an expert report or an opinion? Do you need an expert's conclave? And undertake a risk analysis with your client. This is really important because this goes back to your paramount duties to your client. Your client needs to be aware before they commence litigation or mediation or any other ADR process what the risks are. To do that, I think you should prepare a document and you can reuse it. And in that risk analysis document, the aim is to identify the legal risks, the commercial risks, and the personal risks for the client. In undertaking a risk analysis with your client, I would first say that to identify the legal risks, your document might include prompts. The response that you and your client come to may lead to further consideration and further questions. Okay, so you're preparing a document which you use when you're taking instructions from a client, and it provides you with an opportunity to ask yourself and consequently deal with the client about certain issues. Is the law clear? What are the prospects of success? Are the facts clear? Will your client come up to proof? Will witnesses be available and come up to proof? Does the other side have evidence that is disadvantage to you or your client, or likely to come up to proof and likely to come up to proof? And can I rely upon external objective standards? Let's take, for example, number 3, are the facts clear? There's really no point going into a mediation session if you don't have a clear idea of the facts and your client doesn't have a clear idea of the facts. That's part of reality testing. You run through the matter with the client, play it out logically as if you're in a court situation, and say, right, that's all very well to allege that you have suffered damage as a result of breach of contract, but on the facts, is there really a contract? Think about what are the elements of a contract, and think about what evidence you need to establish what it is that you're trying to argue, either in a mediation or in a court. And the point that I guess I'm trying to make is that your preparation for an ADR process should be, in very many ways, the same sort of process that you adopt as if you're going into a court litigation battle. You need to prepare your client well before you go to mediation. Invite your client to identify and consider the commercial risks. And here are some prompt questions. You could put this in your own flowchart or your own document. What are the legal fees to date? What are the likely further legal fees? What are the prospects of a court making a costs order, either for you or against you? What are the likely additional fees, experts, travel, counsel, whatever? If the matter doesn't settle, what is the opportunity cost to your client? That's often overlooked. I guess the prompting question is, if you weren't involved in spending $100,000 and a year of your life in this litigation, what would you do with that $100,000 and what would you do with that year? Are there other things that really make it sensible to resolve this dispute much sooner rather than later? And does your client have issues associated with a public hearing? It may be for a commercial client that they would not wish to risk any adverse finding that might affect reputation or commercial relationships. These are the sorts of things that you need to do in preparing your client before you go into a mediation session. And then think about the personal risks. Clients sometimes are so focused on getting the other side and winning the case, they forget about the cost, not in terms of money or time, but in other things. What is the stress levels on the client? What are the stress levels on the client's relationships, on those that are close to the client? In real terms, what will be the effect of litigation on home life, time and money, work performance, and health? You see, it's very sad if at the end of the battle, even if the clients win, they lose relationships, they lose opportunities, they suffer ill health, and they go through stressful. Clients need to think about those things from the start. And I see from the chat that there are some comments about connection issues. I do hope that you can hear me reasonably clearly. I don't have the best internet connection here, I'm sorry, but we'll keep trying. You need to prepare for the ADR process, prepare your client, and also think about your tactics. Before you get into the mediation session, you should have this sorted. Will you speak as the lawyer, or will you have your client speak? Will your client extend an offer, or will you do the opening offer? Now, things don't always go to script, and I've suggested that you should be light on your feet and be flexible and ready to change. But these are important things to think about as you prepare for the process. So here's an example of a checklist that you might want to run through with the client and be prepared to raise during the mediation session. What are the real issues for your client? Now, we might know that the dispute relates to unpaid wages, but your client might really have issues in relation to failure to be considered for advancement in the organisation, or simple acknowledgement for good work, or failure to have a voice when it comes to implementing new ideas. They might be the real issues for the client, even though the litigation is about unpaid wages. What are the issues for your opponent's client? Think about that. Maybe this is a dispute about unpaid wages, but the real issue for the opponent's client is that a competitor is creating a great deal of stress and uncertainty. What does your client want? I know that might seem silly, but what you ask for in litigation isn't necessarily, very often isn't, what your client actually wants. Maybe your client doesn't want money so much as peace of mind. So ask yourself ask your client what they really want. And in doing so, you ask your client what is their best alternative to a negotiated agreement, their BATNA. What is the client's WATNA? What is the worst alternative to a negotiated agreement? Now, when I talk about a negotiated agreement, I mean if you have an agreement at the mediation, that's fine. But if you don't, what's the best thing that will happen? What's the worst thing that will happen? You need to consider brainstorming and how can this be resolved? Think of all sorts of ideas. Even if they're silly ideas, is there some way we can resolve it? You have a problem with the employer not paying your wages? Well, can you buy the company? No, I can't. At least we considered it. We brainstormed that option. What improvements in your client's life will there be if the matter is settled? What is the financial, emotional and health cost if saved, if settled? And what is the financial, emotional and health cost if the matter is not settled? All right, I'm just going to stop the share now. If I can find the correct button to do so, just bear with me. There it is. Okay, thank you for your patience. Look, I know that we haven't finished that presentation. I'm sorry that I've just been speaking at you tonight rather than being interactive. You know my thoughts about PowerPoints, but hopefully you found tonight's session useful. I do propose to continue with it next week, where we'll pick up at point number 6. I won't load the PowerPoints on just yet. One of the reasons I don't like to load PowerPoints on is that instead of listening and writing, people tend to look at the PowerPoint and read it, which is, I don't know, maybe it's just my preference in that regard. But next week, I also want to cover the issue of the mediation process in a little more detail, specifically to help you with the first assessment. What I'd really like is if everyone could have their groupings organised by next week. And if everyone could think about their opening statement. What is it that you would put in your opening statement if the assessment was next Thursday night? Don't write a script. Write words, dot point, number, whatever. Maybe phrases, but don't write a script. Now, one of the words might be confidentiality. Another word might be process. Another word might be whatever you choose. So what we really want you to do is start to think about what you're going to say in your opening statement in the mediation session for assessment number 1. Now, Karen, did you have a question?
Yes, please, about the assignment. I just wanted to clarify, it talks about a brief written document scenario of no more than 300 words, but at the top of the assignment, it's got a line that says maximum word limit 2,000 words. And I just wanted to clarify what that was for.
Probably a mistake, I'm sorry. My real intention is this. To be honest, I'm not going to mark you down for the words. That's not the assessment. The assessment is what you do on your feet, so to speak, as the mediator or the conciliator. That's what I'm really after. But I do want you to give me just a few words telling me whether you are doing a mediation or a conciliation, and just giving me a few words about the basics of the dispute. So, look, it's it's an issue to do with family law or neighbourhood, or commercial dispute between directors, or a criminal, mediation, whatever it might be, and just a few basic points. So, not much. Sorry about the 2,000. That's probably a mistake. But thank you, Karen.
Thank you.
Now, any other questions? All good? I know hopefully it hasn't been too tedious tonight. Thank you for your patience. I really appreciate it. I'll end the session now unless there are any questions. All good? Okay. Well, we'll see you next week. All the best. Bye.